So, yeah. Hi all. Okay, welcome back. Right, this is Mani Chandana. This is CA Mani Chandana. Okay, so let's continue with the next topic, that is corporate wealth theory. Okay, this is a legal concept wherein it's just a continuation of one of your what the features of the company, wherein the first one, the separate legal entity. So this particular concept is also the same, wherein we identify the company uh, different from the members of the company. It's the same concept. We've learned that in detail. Okay, here in corporate wealth, there is a very important and a landmark judgment, that is Salomon versus Salomon and Company Limited. So that is very, 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 very important, and it is one of the uh, landmark judgment of this corporate law. This was in the year, in this 1800s, very old case law. Okay, and it's not an Indian case law, it's a UK case law. Fine, let's just begin with our the subject. Okay, and the corporate will is it's the same thing as the separate legal entity concept, which we have already studied. Okay, and we'll just read whatever is there in that, and then let's begin with our the most important case law of the Companies Act. Okay, one of the important case laws of the Companies Act. Okay, let's begin. So just come to page number 452, everyone. Okay, and as you all know, this is a book which is compiled by me. Okay, I'll be using this particular book. So if you want to purchase this book online, you can do it online on our website HM Commerce, on our website hmclasses.com, and on our app HM Commerce Education. Fine. I think you all know that, right? Okay, and this book, I have not deviated any thing from your institute material. Okay, it's exactly the same. It's just that I have added in my, something like these. You can see all of these pictures. I've tried to represent the case laws so that you can remember it for your, it's easier for you to study, and it's not boring, and it's always kind of always, whenever you study, the book should be interesting. That is how I used to feel, and I always used to make my own notes. How much ever I study from the textbook or whichever book, I always used to refer to my notes. That would at any time help me during revision, during the day before the exam. It's always, whenever you write yourself, or when you feel the book, when the book you study is more comfortable, it is kind of easier for us to understand and relate with whatever we study. It's the amount of the absorption of the material or the concept is more when you have a interactive book, and a book which you write. The obviously, the from your schooling, when even in your school, when it's always, you used to feel better when you read your class notes when compared to the textbooks. Yes, you were always comfortable with your class notes, but I don't call this as a class note because this is nothing but your textbook. It's your textbook made in the form of a classwork. I've tried to use all these handwritten notes so that it looks familiar. It doesn't look like a textbook. It is your textbook, but doesn't look like one. And it's always good to read from something, from a material which is colorful, and which has so many pictures. That is how I used to feel. That is the inspiration I got to design this particular material. Right? Okay, all of that aside, let's start with the topic. Anyways, if you want this particular material, you can anyways purchase it from our website or the app. Okay, fine, great. Okay, corporate will, page number 452, right? Okay, corporate will refers to a legal concept. It refers to a legal concept whereby the company is identified separately from the members of the company, separate legal entity. We have done everything in detail, right? Okay, the term corporate will, it's also called as corporate insulation. Children, this concept is also called as corporate insulation. Now, what do you mean by corporate insulation? Corporate insulation is nothing but, it is nothing but the shareholders are protected from the acts of the company. The shareholders are protected from the acts of the company. We also discussed about the limited liability. Yes or no? That is, the debts of the company are the debts of the company, and it has nothing to, and the members of the company have nothing to do with the debts of the company, right? If the company incurs any debts or it does any contravention with respect to the law, the company is the one which is held liable and not the members of the company. See, corporate veil meaning, what is a veil? Veil meaning some kind of a, you can see, see, if you can see this veil, which usually covers, yes, it is something which is used to cover something. It's a veil, right? Or corporate insulation. We are talking corporate insulation, meaning what? That the shareholders are insulated or they are protected from the acts of the company. The shareholders are protected from the acts of the company. The shareholders, even no, not the shareholder, the company, if whatever the debts the companies make, or any any, if the company contravenes any law, the members of the company are not responsible for the same, right? Getting my point? Yes, ma'am. Okay. The corporate will refers to concept that members of the company are shielded from the liability connected to the company's actions. They are shielded. There's a veil which is covering them. They are shielded, they are protected, or they are insulated from the company's actions. Getting it? Yes, ma'am. If the company incurs any debts or contravenes any laws, the corporate veil concept implies that the members should not be liable for those errors. We as members are not liable for the actions of the company. That is nothing but the corporate veil or the shield or the insulation, corporate insulation. Yes, simple, very simple, because we know the features of the company in detail. We have spent so much of time learning the basics of it. Obviously, the later topics must be very easy for you all. Yes, if you are not strong with the basics, obviously all of these topics would go above your head, because the basics, the features of the company, we have spent so much of time learning all of it. All of this will look very easier, right? Good to go. Okay, the next topic is the case law Salomon versus Salomon and Company Limited. Salomon versus Salomon Company Limited. Ma'am, wait, what is it? Ma'am, wait, what is it? Salomon versus Salomon and Company Limited. Read the case. Salomon, that is that person, okay, versus the name of the company. Versus the name of the company. Very, 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 very important. Okay. I told you all of the topics are important. This is also important. Okay. See, Salomon versus Salomon and Company Limited. Okay. What happened in this particular case? Let's see the facts of the case. Very interesting. Okay. It's always nice to discuss any case law. When it comes to a subject like law, it's always, law is a practical subject, children. Law is a practical subject. It's not theory. Even though you write, it always involves application of mind, what has actually happened, how the cases have been dealt in the courts. All of this is very interesting, right? Okay, see, okay, let's discuss about the facts of the case. What actually happened? Okay. Fine. Even before we discuss about the facts of the case, I just want you all to know what are shares and what are debentures. Okay, just a small, very small. I'll just explain what are shares and debentures so that it will be easier for you to understand the concept. Okay, fine. Wait, students, what do you mean by shares? What do you mean by shares? What do you mean by shares? See, shares are nothing but units of ownership. They are nothing but units of ownership of a company. Okay, units of ownership of a company. Yes or no? Yes. Meaning, say for example, if I have to become a owner of a company, if I have to become owner of a company, say ABC Limited, okay, what do? I purchase shares of the of that particular company. What are shares, ma'am? Shares are nothing but units of ownership of the company, which the company issues so that the public can buy and become the owners of that particular company. Getting my point? Shares are nothing but units of ownership which the company issues. Say, for example, you or your friends or your family or anyone, if they buy those shares, they become the owners of that particular company. The more number of shares you have, the more number of stake you have in that particular company. Yes, my point is very simple and clear. The more number of shares you have, the more number of stake you have in that particular company. Simple. Shares, everyone knows. It's just a basic understanding I'm trying to give you. Okay, now let's understand what are debentures. Let's understand what are debentures. Have you all learnt debentures? Do you all know? I hope so. If not, I'll just give you a basic information about what these debentures are. Usually, these debentures are long-term debt instruments. Usually, these debentures are long-term debt instruments. Okay. Okay. Usually issued by companies. Usually issued by companies. Okay. Usually issued by companies. What are these? These are debt instruments. These are debt instruments, but shares are equity. Shares are equity, whereas debentures are debt instruments. Okay, issued by the companies, wherein, okay, where the issuer, promises to pay to pay interest at regular intervals along with the principal repayment. Along with the principal repayment. Getting it? Meaning what? Ma'am, you just wrote something we are not able to understand. Okay. Say for example, there is a company. Again, say ABC Limited. Okay. ABC Limited issues, say 10% debentures. Say 10% debentures to you. Say for example, Mr. A. To Mr. A. Now, if Mr. A purchases the debentures of ABC Limited, if Mr. A purchases, if he what? Purchases the debentures of ABC Limited, it means that he is giving money or he is lending money. Lending money to ABC Limited. Lending money to ABC Limited. That means that ABC, obviously these are debt instruments. So ABC is taking loan. ABC is taking loan from A, from Mr. A. Getting it? ABC is taking loan from Mr. A. If Mr. A is purchasing debentures, it means that he is giving money or giving loan to ABC Limited, and ABC Limited is taking loan from Mr. A. Okay, and now who is issuing? ABC is issuing. So this will pay interest and also repay the loan. Loan meaning the entire principal amount. Okay, say for example, if this is 10 lakhs, So principal will be 10 lakhs. And this is 10% debentures. See, what do you mean by this? 10% debentures, meaning this is nothing but the interest rate. Children, this is nothing but the interest rate of the debentures. Okay, interest rate, or you also call it as coupon rate. You also call it as coupon rate. See, usually the debentures are issued, we call it as 10% debentures, 6% debentures, okay, 12% debentures. What are all of these? These are nothing but the coupon rates of the debentures. That is the interest rates. So these interests are paid by the company, that is the issuer of the debentures, at regular intervals, and also it will repay the principal as well. Okay, getting it? So usually, what are these debt instruments? Debentures. Debentures are usually the debt instruments which are issued by the companies. And whenever you purchase the debentures, it means that you are lending money. You are lending money to the company. Getting it? Simple. Okay. Fine. This little understanding I wanted you all to have so that we can understand the case law even more easily. Okay. Let's just read what happened in the case, the facts of the case. Okay. See. What is the name of the case law? Ma'am, Salomon versus Salomon and Company Limited. Salomon versus Salomon and Company Limited. See, there is this one person here. Ma'am, who is this, ma'am? This is Mr. Salomon. This is Mr. Salomon. Okay. This is basically a shoe business. He is into the business of manufacturing and selling shoes. That's the basic business of this person. Now, what he does is he forms a company. He registers or incorporates a company. Who, ma'am? Salomon, Mr. Salomon. He incorporates a company called Salomon and Company Limited. What is the name of the company, children? The name of the company is Salomon and Company Limited. Okay, ma'am, who are the shareholders of this particular company, ma'am? Who all are the members or the shareholders of this particular company, ma'am? Please tell me. See, this person again here, Salomon. Yes, he is the member of the company, shareholder of the company. His wife. What, ma'am? Salomon is like one old tata, and his wife is like Kangana. Is so young. He's so young. Yes, fine. It's okay. Okay. Who are all the shareholders? One, Mr. Salomon, his wife, okay, his 4 sons here. 1 son, 2 sons, sorry, second son, third son, and this is the 4th son, and also 1 daughter. His entire family. Himself, his wife, 4 sons, and 1 daughter are the members of the shareholders of this particular company, Salomon Company Limited. Getting my point? Getting my point? Yes, ma'am. Now, later what he did? Mr. Salomon transferred the personal business asset. One second. This is asset. It has become assets. It is assets. ASSETS. Okay. So what did he do? He transferred his personal assets to the business. He transferred his business assets to the business. So nothing but capital. It is nothing but capital. Yes. Now this became the property of the company. Whatever he invested or he has given as capital, it becomes the property of the company now. Of company different, members different, even though he transfers, it is now the property of the company. So he transferred so much, 38,782. See, children, this is actually in pounds. It is actually pounds 38,782. But for simplicity, so that you all can understand when I tell it is in rupees, I have just taken this as rupees, but it is actually pounds. Okay, fine. Now he transferred, and in return, Salomon took 20,000 shares. See, he's taking shares. You know what is shares? Ownership in the company, in this particular company. So he took how many shares? He took 20,000 shares of rupees 1 each. See, again, this is pound 1. Again, don't come asking, ma'am, in your book, there is some symbol like this, ma'am. Now here you have written rupees, ma'am. What is this? This symbol meaning it is pound. Okay, fine. For simplicity, I've used rupees. Okay, so that it's easier for you all to understand. So he took 20,000 shares of rupees 1 each, and then he took what? Debentures. Oh my God, what are these debentures? You all know, right? So he took debentures worth rupees 10,000 secured. Ma'am, what is this secured? Okay, children. See, in debentures, again, you have secured and unsecured. Basically, what do you mean by secured? if a loan, basically debentures are nothing but loan, yes or no? So loans can be secured, they can be unsecured. What do you mean by secured loans or secured debentures? What do you mean by it? It means that the loan is secured by the assets of the company. Meaning, I'll come again. The loans are secured by the assets of the company. Meaning that if in case the company cannot repay back the loan, or if the company cannot repay back the debentures, I mean the principal amount of the debentures, it is secured against the company's assets. So any time this particular debenture holder can recover it from the assets of the company, meaning they are secured by the assets of the company. If in case the company cannot repay, if the company cannot repay the loan, the assets will be sold. The assets will be sold and the amount will be paid to the secured debenture holder. Getting it? Simple, easy. So what kind of debentures were these? These were secured debentures, secured by company's assets. Clear? Okay. Next, the balance he took cash. Whatever the balance, he took it in cash. Okay. Now till here what happened? Till here what happened? Again, what is the name of the case? Salomon versus Salomon Company Limited. Okay. What happened? There is this one person called Salomon, and he formed a company called Salomon Company Limited. Who are all the shareholders? He, his wife, his 4 sons and 1 daughter. Okay, he bought in assets into the company of say pounds 38,782, and in return he took 20,000 shares of rupees 1 each, pound 1 each. Also debentures of pound 10,000 or rupees 10,000, which were secured, and the balance he took it in cash. Clear till here? Yes, ma'am. Okay, next what happened? Next what happened is, subsequently this Salomon and Company Limited is there, no? This particular company, it went into liquidation. It went into liquidation. No paisa. No paisa, papa. No paisa, papa. Company went into liquidation because of general trade depression, they'll tell, but because of some reason, because the business could not run as expected, and the assets were not more than the liabilities were more than assets, meaning the assets were not more than the liabilities, and it could not pay. It was difficult for it to run the business, so the company went into liquidation. The company went into liquidation. Clear? Okay. Yes. Now, okay, in the process of liquidation, children, what happens is all the assets are sold. Assets are sold and the liabilities are paid. The assets are sold and the liabilities are paid. Now, when the company goes into liquidation, it is obvious that the assets are not sufficient to pay off the liabilities. Yes or no? The assets, if there is sufficient amount of assets, and if everything is good, why would the company normally liquidate? Yes or no? So the fact that it has gone into liquidation, the probable reason could be lack of funds or lack of assets to continue the business. Now, in the process of liquidation, what will happen? The assets are being sold, and the assets are sold, and it is paid off to the liabilities, and whoever whoever are the creditors or the debenture holders, all of these assets will be paid. Okay, and now very important, there is an order of payment, children. See, there is an order of payment when a company liquidates. This usually you study in your winding up chapter in your coming, not in foundation. For the due course of time, you will study a winding up chapter, and there is also called, I also told you about IBBI, you remember, Insolvency and Bankruptcy Board of India. So there we discussed about Insolvency and Bankruptcy Code. Everyone, yes. So Insolvency and Bankruptcy Code, here also there is something called waterfall mechanism. That is nothing but the order of payment of dues. Whenever a company liquidates, there is an order of payment. When the assets are sold, the first amount of whatever you get from that selling of assets, that should be used according to this particular what do you call? According to that particular mechanism. Okay, there is a order of payment, and now you have to follow that particular order. So all of that is not required now. Ma'am, you said something, ma'am. Not required, children. You just have to know there is some kind of order of payment, wherein usually, not usually, every time, the secured loans or debentures are paid first. Next comes unsecured creditors. Next comes unsecured creditors or loans. Later comes preferential shareholders. The last comes equity shareholders. Towards the end comes equity shareholders. Now, children, what they're trying to tell you here, okay, what I was trying to tell you is here is whenever the company goes into liquidation, the assets usually are not sufficient to pay off all the liabilities, and whenever you sell the assets, there is an order of payment. So whatever the amount you get, first the secured loans or the secured debentures, whoever have given loans, they will be paid off first. Next, if anything is left out, then we will give it to the unsecured loans or debenture holders, whoever it is. Later, if something is left, then it goes to the preferential shareholders. Even then, if something is left, then it will go to the equity shareholders. Usually, in case of liquidation, equity shareholders don't get anything. Okay, fine. Now, okay, let's see what happened here. Let's see what happened here. See, this fellow had, this Salomon had rupees 10,000 secured debentures. Yes or no? In the same company, there were few creditors who were unsecured. One second. Children, these are unsecured. There is some mistake. Okay. Okay, one second. Make this unsecured creditors. Okay, fine. So there were unsecured creditors also in this company to the for rupees 7,000. For rupees 7,000, to the tune of 7,000 or pound. Okay, basically 7,000 rupees. Okay. Now, when the company goes into liquidation, obviously, when the assets are sold, it will be first paid to whom? First paid to secured debenture holders or secured loans. Yes, who is secured now? This fellow, Mr. Salomon. He is holding secured debentures. Whereas these real third party who have actually lent to the company, these are unsecured creditors. Meaning their loan is not secured by the assets of the company. So if the assets are over, if the assets get over by paying off to the secured debenture holders or the secured loans, now these people being unsecured creditors, they don't get anything, or they'll get only little, solpa. Getting it? So these people are like, they are protesting. See, Salomon is not a secured creditor. You cannot pay him first. Please pay us first. First, please pay us first. You cannot treat him as a secured creditor. You can, because he is only the owning the entire company. Yes or no? He is owning all of the shares. His wife, his children, all of them are the shareholders. He is only managing the company. He is only taking care of the business. He is only the business also. Before also it was same. After converting it into a company also it is the same. So you cannot. So these unsecured creditors have come to protest, telling to the court, telling no. Salomon cannot be paid first. First clear our dues. First clear our dues. What will happen? What will happen? What will the court tell? The court will tell, chal re, company is different, members are different. So you know that members can contract with the company. You all know that company can enter into contract with, the members can enter into the contract with the company. They can also buy the debentures. Yes or no? So that is what happened, no? That's what happened here. Now how can you tell Salomon Salomon and company are the same? No, Salomon is different, company is different. Salomon is a member of a company, yes. Member has also purchased debentures of the company. Oh, what's wrong? What did the court tell? What did the court tell? See, company is different, members are different. Wow, my students, you understood this concept so well. Why did you understand? Because you know the concept, yes or no? See, the unsecured creditors contended that Salomon could not be treated as a secured creditor in respect of the secured debentures held by him. Why? Because he only has everything. He only has the shares. His daughter, his wife, everyone are the shareholders. Yes or no? So they are crying. Papa, they are crying. Okay, but what did the court tell? Court said company is different. See, company has its own separate existence and is different from its members. God, this is what we are trying to learn. No, this is what we are trying to learn. This is the basic. This is the most important feature of a company. Yes or no? Yes or no? Yes, we all know. Oh, same, no? Yeah. See, as the company was duly incorporated, meaning it was correctly incorporated, it is an independent person. Oh, it is an independent person with its rights and liabilities appropriate to itself. Yes or no? And that the motives of those who took part in the promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. See, this case law was in the year 1800s, 1890s or something. Okay, getting it, UK case law at that point of time. So they're telling the motives of those who took part in the promotion of the company, meaning the promoters or the promoters of the company are absolutely irrelevant in discussing what those rights and liabilities are. So it said no unsecured creditors, no, you cannot ask us to pay you first. You cannot ask us to deny the fact that what Salomon should not be treated as a secured creditor. Getting it? Secured debenture holder. They lost meaning actually Salomon went to court versus the Salomon versus Salomon Company Private Limited, Salomon Company Limited. Okay, but somehow Salomon could win the case. Okay, fine. Let's read. Clear till here, everyone? What happened in the case? Let's read it again. Simple, everyone. Yes, ma'am. Salomon versus Salomon and Company Limited. Facts of the case. What happened? In Salomon versus Salomon and Company Limited, the House of Lords meaning similar to a Supreme Court, UK this is, laid down that a company is a person distinct and separate from its members. Wow. Okay, in this case, one Salomon meaning that person Salomon incorporated a company named Salomon and Company Limited with 7 subscribers consisting of himself, his wife, 4 sons and 1 daughter. Yes, you all know. This company took over the personal business assets of Salomon for pounds 38,782, and in return Salomon took 20,000 shares of pound 1 each, debentures worth 10,000 of the company with charge on company's assets, meaning they were secured, and the balance in cash. Okay, you all know. His wife, daughter and 4 sons took one share of pound 1 each. Okay, subsequently what happened? Company went into liquidation. Why, ma'am? Due to general trade depression. Okay, it could not run its business. Now what happened? See, the unsecured creditors to the tune of 7,000 contended that Salomon could not be treated as secured creditor of the company in respect of the debentures held by him, as he was the managing director of a one-man company, which was not different from Salomon, and the clock of the company was a mere sham and fraud. So they are trying to tell he is the only one who is managing everything. He and his family are only the members of the company, and the clock of a company, clock meaning that one big coat you have seen, no, in Harry Potter, one big coat which will cover. So whatever he is telling, he has created a company that is just it is nothing but fraud. So you please don't treat him as a secured creditor is what they're trying to tell. Now, but it was held that the company is at law a different person altogether from the subscribers to the memorandum, and though it may be that after incorporation the business is precisely the same. Business is the same even before, after incorporation, and the same persons are managers. See, shareholders can also be managers. See, the management can also be different. It can also be the same. The owners can also run the business. You cannot tell owners cannot run the business only. No, if you are capable enough, if you can, yes, you can anytime. Yes. See, for example, Infosys, Mr. Narayana Murthy, he was the founder. He was also the director. Now he is not. That is a different thing. He was the founder. He was also the director. Yes, he was also owning. He was also managing the business, right? Okay, and the same hands receive the profits, The company is not in law the agents of the subscribers or trustees for them. You've learned this. The company is not the agent of the members of the company, right? Yes, nor are the subscribers as members liable in any form or shape or form except to the extent and in the manner provided by the Act. Thus, this case clearly establish that company has its own existence, and as a result, a shareholder cannot be held liable for the acts of the company, even though he holds virtually the entire share capital. Yes or no, children? Yes. See, the whole law of corporation is in fact based on this theory of separate corporate entity. Getting it? How important things what all important things we are discussing today in class. The whole entire law of corporation is in fact based on the theory of separate corporate entity. Didn't I tell you the first day when we started discussing about the features of the company? Didn't I tell you this is the most important feature of all of the features of the company? Separate legal entity. This is one of the most important concept wherein the company form of organization is based on. Getting it? Yes, everyone? Yes, ma'am. So now if you're clear with this, if you are clear with this particular thing, it's obvious that by this time a question might have arisen in your brains that, ma'am, if something like this happens, there are so much of chances of taking advantage of the situation. People can take advantage of this situation, ma'am. They can create a company, do something which is not correct, and they can clearly escape because their personal assets are not attached when they do something like this, when they do a fraud. Basically, I'm telling you that there might be a question in your head that, ma'am, if there is such a thing in law that you can create a company and you are not held liable for the acts of the company. Even you do, the company is held liable and you do not have to pay a rupee from your pocket. Or it's obvious that everyone will form a company and do some misuse of that particular company, and basically harm the public. Yes or no? Yes or no? Yes. So the answer for that is the next topic which you're going to learn is lifting of corporate veil. That is the next topic which we will be discussing, that is called lifting of corporate veil. Getting it? Now, what does this mean? Now, what does this mean? I know I have laid a very good foundation for you all, wherein there is something in your mind that yes, members are different and company is different. Company has a separate legal entity. It is a different in the eyes of law. Yes, this foundation is strong. Very good. Very good. Okay. Still, read now. Okay. Now, the question might arise whether this veil of corporate personality can even be lifted or pierced, meaning that whatever the corporate insulation which you have given, wherein the members are not responsible for the acts of the company. That is the kind of insulation or the veil which you have put to cover or to protect the members of the company. To protect, basically they are in a shell. You're protecting that particular shell, or the insulation or the veil is protecting the members inside that particular whatever the veil. Okay, now the question might arise that whether you can take off that insulation, whether that particular veil can be lifted or whether it can be pierced, so that the persons who are actually responsible for the whatever that could be. You will read whenever what are the when will this lifting of corporate will be done in the law. But these people who are responsible, they will be put upfront. Yes, getting it? Right, ma'am. Now, next, see, before going into this question, one should first try to understand the meaning of the phrase lifting the veil. I told you, it means looking behind the company as a legal person, that is disregarding the corporate entity and paying regard instead to the realities behind the legal facade. I'm telling you. So if they are inside that particular shell or that particular veil or the insulation, you're going to remove that. You're going to remove that, or you're going to disregard that the company is a separate entity. You're going to disregard that company is a separate entity from the members. You are going to treat the members and the company as one and the same. When does this happen? When does this happen? You're going to see. Okay, fine. Where the courts ignore the company and concern themselves directly with the members or managers. So court will tell, Array, just get lost. What you're talking, company, company, company. You have done everything. You come front, leave that company aside. Yes, when does court tell this? We will learn. Okay, fine. The corporate veil may be said to have been lifted only in appropriate circumstances. See children, whatever you have learned till now, that is a basic concept. That is how the company form of organization works. But when the court feels that something is happening, something bad is happening, obviously in appropriate circumstances, the courts are willing to lift the corporate veil, and that too when questions of control are involved rather than merely question of ownership. See what is happening. See, ROC or the court will, ROC meaning Registrar of Companies. Okay, basically you will know the importance of ROC. Basically incorporation, all your filing, everything will go to this person. He is the registrar, not register. Okay, he is called Registrar of Companies. Registrar of Companies. Okay, he's basically a person. Okay, yeah, he's a head. You will have to your incorporation documents, your annual returns, everything will be submitted to ROC. Okay, fine. See what is happening. They are lifting or they are piercing the corporate veil. They are removing the corporate insulation. Getting it? Fine. The following are the cases where the company law disregards the principle of corporate personality or the principle that company is a legal entity distinct and separate from its shareholders or members. See, what is it? It disregards. It is disregarding that company is different and members are different. The court will see as the members are only responsible for whatever the acts of the company. Getting it clear? Very simple. No? Very simple. No? Now, what are those, ma'am? We want to see. Let's just read it once so that you are familiar with the headings, and later we will discuss one by one each. Okay. Fine. The first one being to determine the character of the company, that is to find out whether the company, whether co meaning whether the company is a enemy or friend. I'm just reading, okay? I'm not explaining. Fine. The next second one being to protect revenue or tax. To protect revenue or tax. Third one being to avoid a legal obligation, meaning if to avoid a legal obligation, they've created a new company or a different company, and even at that point of time, the court will lift the corporate veil. Okay. Next, formation of subsidiaries to act as agents. This also you will learn. What is it? Okay. And the last one being the company formed for fraud or improper conduct or to defeat law. Now that particular thought, whichever you had in your mind, that people might misuse companies, right? Company form of organization to do improper conducts. For all of these are covered. Improper conduct, all of these, see, act as agents. See, there are so many situations where the court will lift the corporate veil. Okay, fine. Let's do the first one today. There is one case law, Daimler versus Continental Tire and Rubber Company. I'll just complete this and we will close it for today. Okay, fine. So what will we be discussing? Lifting of corporate veil. Okay, and what does that mean? Obviously, you are going to disregard that company is different and members are different. We are going to treat that members are only responsible for whatever the acts of the company. Clear? The concept of lifting of corporate veil is clear. Yes. When does that happen? We will see. The first one we are going to see now. Okay, to determine the character of the company, the court will lift it since. The court will lift the corporate veil. What do you mean by that? To find out whether the company is an enemy or friend. Enemy or friend? What are you talking? Let's see in the case law. Let's see that particular thing in the case law. Okay, what is the name of the case law? Daimler Company Limited versus Continental Tire and Rubber Company. Daimler Company Limited versus Continental Tire and Rubber Company. See students, when we are talking about the any case law, see basically there is someone called plaintiff and defendant. Plaintiff and defendant. Ma'am, what is this plaintiff? What is this banana plaintiff and all you're talking, plaintiff leaf, all of this? No. Okay, what do you mean by plaintiff? Plaintiff is the one who will basically initiate the case in the court of law. This is the person who will actually take the case to the court of law. Plaintiff against someone. Obviously you're filing a case against someone. That other person is the defendant. That other person is the defendant. Getting it? See here, if we are talking Daimler Company Limited versus plaintiff versus Continental Tire and Rubber Company, the first person will always be the plaintiff. The name, I'm talking about the name, plaintiff. Okay. In the case law, the first party will always be the plaintiff. That is the one who has approached the court. Getting it? And the second party is always the defendant. Okay. This is the usual rule. Okay, the first name of the company, not the company or any party, the first party will be the plaintiff, that is the one who has approached the court, and the other one will be the defendant, that is the against whom that plaintiff has filed a case on. Clear? No? Hey, general knowledge appa. If you don't understand, leave it. Okay. Case law, Daimler Company Limited versus Continental Tire and Rubber Company. Ma'am, what happened in this case law? Come on, come on, come on. You're all excited. Yes, as much as me. Yes, more than me. Okay, very good. Fine. Okay, Daimler Company Limited versus Continental Tire and Rubber Company. What happened in this? What are the facts of the case? Come on, let's learn. Okay. See, there is one Continental, you all know Continental Rubbers, Continental Tire and Rubber. You would have seen this na? On tires, car tires. Continental is a very famous brand, Continental company. Okay. So this is a company which is basically incorporated in England. It is basically incorporated in England. It is a it's incorporated in England, meaning it's an England company, right? But all the shareholders of that particular company, that is Continental Tire and Rubber Company, all the shareholders were Germans, except for one. Okay. So now what I'm trying to explain you is Continental, whatever this particular company, it was incorporated in England. It was incorporated in England. Matlab it is a England. It's a company related to that England, right? But all the shareholders of that particular company were Germans. They were Germans, except one. Now, what happened was this Continental Tires, this Continental Tires, it supplied tires. Continental Tire and Rubber Company, this company supplied tires to Daimler Company. To whom? To Daimler Company. Where is this Daimler Company located, ma'am? This is located in UK. This is a UK company. Daimler Company is basically a UK company. Continental supplied tires to Daimler Company. Yes. Now, after it supplied tires, what happened was it asked for payment. Continental Tire, obviously, it supplied tires and it is asking for payment. Now, this Daimler Company says that, see, Continental Tires, see, wait, just listen, okay? I know I have to pay you, but just listen to what I'm trying to tell you. You Continental company are there, no? All your shareholders are Germans, man. All you see, this person in Daimler is talking to one person here in Continental Tires. He is telling, see, Continental Tires, you first listen to me. All of your shareholders are all Germans, man. I am a UK company. And you know, now all world war is happening. I cannot have a contract with you because it is against the laws of the country. It is the laws of the country. So I cannot, this contract is only void, man. I cannot pay you. I don't have to pay you. Is what? Who is telling? Daimler Company is telling. To whom? To Continental Tires. It is telling that, see, okay, I understand that I have to make payment to you, but the thing is, now we are in a war kind of situation. World war is happening, and we are in a war kind of situation. See, even all your shareholders are Germans, man. So basically, you're a German company. Even though you're incorporated in England, I don't care all of it. All of your shareholders are German, and UK and Germans are enemies. So me being a UK company, we cannot pay you because you are an enemy company. As per the law of our land, we cannot enter into contract with the enemy companies. So whatever the contract we have had is void. What do you mean by void? You will learn in your Indian Contract Act. But void meaning these are not valid contracts, and I don't have to, these are basically not enforceable by law. Void contracts are not enforceable by law. Even if you go to court of law, there it is not, you cannot go and tell, you cannot go and ask for money or whatever. Fine, getting it? So this fellow is telling that particular contract is void and I don't have to pay you. Continental Tires is like, what are you talking? See, I am a company incorporated in England. I am a I have a separate legal, I am a separate legal entity. The company is a separate legal entity. It is different from the members. It is different from the shareholders. Shareholders can be Germans, whomever it is. Please don't consider that. I am a separate legal entity. Continental Tires is a separate legal entity. Shareholders could be German, could be someone else. Please, is what Continental Tires is telling. But Daimler company did not listen. It went to court. Yes, it said, see, what happened? See what happened here. Daimler Company Limited denied payment, claiming that any payment to an enemy would contravene the statutory law. That is the law of the land. That is the UK law, and the contract when entered with them is void. So entered them with is void is not enforceable by law. So it does not have to make any payment. Is what Daimler Company is telling. See, Daimler Company is telling. Now Continental Tire and Rubber Company, they are like amused. What are you talking? See, Continental Tire said company is separate legal entity different from its members. Even if my members are Germans, I don't care, but company is not a German company. Please pay us money. Okay, but what happened? What did the court decide? The court lifted the corporate veil. It lifted the corporate veil. It held that even though the company is an artificial entity distinct from its members, it will acquire hostile meaning what? Enemy character, enemy. Hostile meaning enemy. It will acquire enemy characteristics of its majority shareholder. It is seeing the majority shareholders. Who are majority shareholders? German. Now German and UK are enemies. Now why, even though the company is incorporated in England, because of the majority of the shareholders are German and this Daimler company is in UK, these both are enemy companies. So the Daimler wins the case and it does not make payment to Continental Tires. Getting my point? Yes, clear. The case law is clear. Yes, ma'am. Okay, see, the leading case in this point is Daimler Company Limited versus Continental. The leading case in this point is Daimler Company. If the public interest is not likely to be in jeopardy, the court may not be willing to crack the corporate shell. What are they trying to tell? Jeopardy means something danger, risk or danger or risk. So what they're trying to tell you is basically if the public interest is not in risk, meaning, say for example, if there was no war kind of situation, if there was no war taking place, then obviously court will not be willing to crack the corporate shell. Daimler Limited should have paid the amount to the Continental. Yes or no? Normally, if say for example, if we in India enter into a contract with, say for example, a particular country, say XYZ country, and the relations between these two countries are good. Now the court does not intervene in between and say, no, we are lifting the corporate veil. No, until and unless that XYZ company is an enemy company, okay, and there is a war-like situation and the public interest will be in risk, only then the court will intervene and it will lift the corporate veil. Else it will not be willing to crack the corporate shell. Getting it? Yes. But it may rend. See, it may rend the wheel. Rend meaning pierce. Basically, pierce the wheel for ascertaining whether the company is an enemy company. If it is yes, then obviously. It is true that unlike a natural person, a company does not have mind or conscience. Therefore, it cannot be a friend or foe. Obviously, yes, company cannot be a friend or enemy. Foe meaning enemy. Children, foe, what is this? Enemy. Yes, obviously, a company does not have mind. It cannot do any harm to you. See, obviously, it cannot be a friend or a enemy. But, however, it may be characterized as an enemy company if its affairs are under the control of people of the enemy country. See, basically, now Continental Company has all its shareholders as Germans. Basically, they will be having control over Continental Company. Yes or no? So it is possible that may not possible. There is every chance that these German shareholders are influencing Continental Company, even though it is in England. Yes or no? So it is under the control of people of the enemy country. Here, the Germans and UK, they were enemies. Okay. For this purpose, the court may examine the character of the persons who are really at the helm of affairs of the company, meaning who are actually taking care of the affairs of the company, who are actually having control over the affairs of the company. Yes or no? Getting my point? Now obviously company is different, the concept of company is different, members are different. Illappa, no, it is not there. It's the basically whoever are who the shell is being removed, or the veil is being removed, or the insulation is being taken off to see that who are actually the members are only actually uh, uh, at the helm of the affairs of the company. So that is the reason we are going to lift the corporate veil. Yes, understood. Yes, we saw two case laws, two very important case laws today in our class. The first one being Salomon versus Salomon Company Limited, and the second one was Daimler Company Limited versus Continental Tires. Okay, the first one established the fact that company is different and the members are different. Company is a separate legal entity. The separate legal entity concept, the foundation was laid in this particular what? Case law, the corporate veil. What do you mean by corporate veil? Whatever the members of the company are shielded from the liability which are related to the actions of the company, meaning if it defaults any debts or contravenes any law, the members of the company are not responsible. The company itself is responsible. That this is what was laid down in the case law Salomon versus Salomon and Company Limited. But people could take advantage of this situation. Yes or no? Yes, even you felt, you as students felt, yes, if something like this is there in the society, obviously every person is there to take an advantage of the situation. So in order to control all of it, there is a concept called lifting of corporate veil. Lifting of corporate veil meaning what? It disregards the principle of corporate individual corporate personality. Yes, that company is different and members are different. No, lifting of corporate says we are going to remove that veil, we are going to crack this shell and see who is actually who is actually basically the members. The members are basically controlling the company. So we are not going to treat you both as different, and we are going to tell that the principle that the company is a legal entity distinct from and separate from its members or shareholders, we are going to disregard that particular principle in lifting of corporate veil. What did we see here? We saw the case law of Daimler Company versus Continental Tire Company, where we saw how that particular corporate veil was lifted to decide the case. Yes, everyone understood? Clear? Yes. From the next point, let's continue in our next class. Okay, good. Good. I hope you all understood, right? Let's meet in the next class, children. Bye.